Well, let's pick up our discussion now on the copyright and trademark issue that's being disputed in court this morning. And to do that, we're joined by patent attorney Darren Margo. Darren, good morning to you and welcome. And I want to make this as simple as possible for our viewers. So let's start by looking at the terminology, the concept of a copyright and a trademark that form part of the big issue here. What is the distinguishing factor or the differentiation between these two?
Hi, good morning. And I'm going to start by making it even more complicated. We don't have two fights on our hands here. We actually have three. We have trademarks, which in this case is the form of a registered right that is obtained. In this particular case, the logo we're looking at. We have copyright, which actually exists automatically in the expression of the image that we see and that we're dealing with at the moment. And to complicate matters further, we have what we call passing off, which is a common law, which is about the image in its environment as a whole. And in this particular case, the parties have chosen to look only at two. Passing off is not relevant here.
And is this the right route to follow?
It probably is. You know, it's not the first time we've had this. Just a few years ago, we've had the African Democratic Change Party also crossing swords against the ANC with what seemed to be the copying of logos. That fight, I must tell you, if you remember, also fell flat because they couldn't establish the grounds. In that case, they went on the passing off route. But we're not going to go that way. Today we're looking squarely at trademark and copyright.
All right, so the ANC's concern is that the use of the logo and the trademark is, you know, when the public sees this, they will confuse this as an organization or an entity that is connected to the party. Talk to us about some of the contentions that exist in this field in respect of what they're arguing.
You're asking the perfect question. And the place we have to start here is this particular concept. The idea that any one person owns the full and absolute monopoly in the idea of an MP holding a full-length sphere and also holding a full-length shield is not correct. It cannot belong to anyone. There's what we call in copyright the idea and expression dichotomy, which means that the ideas themselves are not protected in copyright. It's the way it appears. And I must tell you, it's not called copyright for nothing. One has to show copying or adaptation. And that's going to be a big problem that the ANC has at hand on this particular matter here. If it can be shown by the MK party, and they may well be able to do it, that they conceived of this idea by themselves independently, that they're going to escape any problems from the ANC. It really boils down to that.
All right, but if you look at them, right, so part of the argument that the MK is raising is that their, the spear, the depiction of their spear is at waist level, whereas the ANC's logo has the depiction of the spear at the top level, and they say it's related to issues around our evolution from an apartheid state into democracy and so on. When you look at these two things together, what are some of the things that jump out at you insofar as the defense that the MK is raising?
You're right. And as always, things are more complicated than they seem. What we must not forget here is that it's not just that image. MK will certainly be making a big deal of the fact that they have a very strong, stark green background, and that's why I believe that they ought to have looked at the passing, or they avoided the passing of argument, because MK, I believe, has a strong ground to be made that they are not looking to ride on the coattails of the ANC. They've established something quite different, and they will certainly have the attention of the judges if this has to go to court. I should also throw out here that this is not the first time. When this matter first arose, my first thought was of the famous painting of the 1880s of the great King Shaka himself with the full feather plume, the full-length spear, and the full-length shield directly in front of him. The same expression of the epitome of the MP that was there going back to 1880s. This is not an open and shut case. It is far more nuanced than the ANC might have us believe.
Would it have helped them, and maybe you can shed some light on this, Darren, when we think, you have an idea or you have a depiction, you then trademark it. How trademarkable is something like this? And I don't know if you're aware whether they have trademarked, this particular logo and name.
It appears not. There's certainly no marking. People would tend to use the R symbol to indicate that a trademark is in fact in place. I have not checked that this morning before the interview. It is a possibility, but I doubt that it's likely. A trademark is something that is used in trade typically to stop other people from competing with you in trade. It is done, but it's not common that these type of things are protected in that area. It is more likely to be in the sphere of copyright as we see today, or passing off as we saw in the case of the African Democratic Change case a few years ago.
If they had trademarked it, would this have been a non-issue? And
it would have been far simpler for them. If they had that in hand now, absolutely, life would have been far easier. It's a lengthy process, by which I mean at least a year and more likely 2 or longer, to go from an application to a granted trademark. So it's not a simple case where the ANC might have quickly filed a trademark application last week and had it in hand this morning in order to get the award that they needed. That's another reason why, of course, they had to look at the copyright ground today.
Yeah, and it's quite interesting. I mean, just on the issue of whether it's trademarked or not, according to the papers that will be put forward and the arguments put forward by MK, is that there was no bona fide use of the trademark by any party. No trademark has been established either in terms of Section 34(1)(a) or C, and I imagine this is part of, intellectual property law. As you see all of these things, these factors together, Darren, it's a big one. It's one that relates not only to purely intellectual property law, but it speaks very directly to South Africa's politics and this massive contestation that is happening. And a victory for either party will actually go a long way in terms of how it influences, one would imagine, their electoral fortunes. So what is your final word and your parting shot on this, Darren, as they go to court, both in the benefit of society for arguing something like this and other, just in the industry itself in terms of IP, patents, copyrights and passing off and so on, and then also just how these things relate to society and become really, really big talking points?
You're absolutely right. I would suggest to you that what this issue is really about is really got nothing to do with copyright or passing off for trademarks. It's about 2 tigers in the jungle who are elbowing for space with an election around the corner, and they're looking to get what they can do in winning the battles. Yesterday we saw a victory for the one side. It may very well have the pendulum swinging today on the other side. This is all about the argy-bargy getting towards the final end. But what will be interesting is how trademarks are used as a pawn in order to get those done. Certainly, next year, this trademark issue is not going to be an issue at all because it's not about trade. It truly has politics at its heart, I believe.
Darren Margo, thank you very much for being available to our program. We appreciate you and we appreciate some of the insights that you have shared with us this morning. I think it clarifies some of the terminologies and exactly what is going to be contested in court today. Darren Margo, appreciate you, patent lawyer there.